Hello and good morning friends, welcome to the CEC-UGC live lecture. Dear friends, as you know that we are carrying a series on general course on intellectual property laws. Dear friends, so far we have conducted ample of lectures for you so that it becomes convenient for you to get in-depth knowledge on this particular series, or I would say on the different topics which we try to bring for you in our different lectures. Dear friends, as I have already told you that we are going to carry this series forward, and today also we are going to talk on this particular series. Today we are going to talk on lecture on patentability requirements in India, and specifically we are going to talk on the requirements of novelty. And for this we have again with us in our studios Mr. Ashwani Sewal. Mr. Sewal is Assistant Professor in Faculty of Law, University of Delhi, as well as Mr. Sewal visits various countries for seminars as well as conferences, workshops, where he exchanges information, he shares knowledge. I hope that his experience is sufficient for you to give you in-depth knowledge on this particular topic, I would say. So without wasting any time, I would like to welcome our guest, Mr. Ashwani Sewal. Mr. Sewal, welcome to the EDSET lecture.
Thank you, Gitika. Welcome viewers. Good morning to one and all. Viewers, if you remember that in our previous discourse, say 3-4 lectures or 3-4 sections, previous sections, we were discussing about the various kinds of subject matter to be given the patent protection. Friends, we are going to start another area, or say another important aspect of the patents in India. That is, what are the following requirements for obtaining the patent in India? We have studied about the subject matter in India. Now we will have to see what are the substantive requirements to be fulfilled by the applicant for fetching the patent protection. If you remember my previous lectures, viewers, I discussed very exhaustively. There are 4 things to be seen primarily when it comes to obtaining the patent on the work of the person seeking the patent protection from the Patent Trademark Office, say in short you can call it PTO. Friends, the very first requirement, if you remember, was the requirement in the form that the subject matter over which the person is seeking the patent protection should not be expressly excluded by purview of section 3 and 4. If it is expressly excluded by section 3 and 4, it cannot be given the patent protection. The another requirement for obtaining the patent, that is novelty, which would remain our today's deliverable or a today's agenda. The next requirement, if you remember friends, as I told you while studying section 2 of the Indian Patents Act 1970, that was in the form of non-obviousness. In Indian context you can call it that there has to be inventive step involved over an invention or with that invention if the person seeks to obtain the patent. The fourth requirement is the requirement in the form of utility, which means in Indian context that there has to be the industrial capability, industrial applicability of the invention invented by the person over which he or she is seeking the patent protection. So friends, I would be discussing and dealing with the very first requirement, which we call a substantive requirement or a substantive qualification for obtaining the patent protection, that is novelty. Our today's agenda or today's deliverable would be understanding the concept of novelty first of all. What does it constitute in India, in Indian context, or otherwise at word in totality? Then the next thing that we will be discussing, what are the different elements of novelty? What are the different ingredients of the novelty or elements of the novelty to be established first of all, or basically to be assessed, gauged by the PTO, Patent Trademark Office, while granting the patent protection or while satisfying the requirement of novelty. The third deliverable for today's discourse would be to understand the novelty or the concept of novelty with the help of case laws on novelty. Friends, the case laws that I am going to discuss would be the case laws decided by the Indian courts and the case laws decided by foreign courts, or say courts of other jurisdictions, especially United States Patent Trademark Office cases and US cases. Friends, a recapitulation in a small slide wherein we have seen earlier in my previous lectures that the substantive requirements for obtaining or substantive qualifications for obtaining the patent are as follows. The invention must not have been excluded by the patent as non-patentable. If by purview of section 3 and 4 it has been explicitly excluded, it cannot be given a patent protection. Then there come another requirement, that is our today's agenda, that is that it must be in respect of a new product or process. So there has to be the novelty for the purpose of obtaining the patent on the subject matter which has not been disqualified on the test of section 3 and 4. Friends, I would like to repeat this point again. I stated that there has to be novelty in the work, in the invention over which the person is seeking the patent protection. If that work is found to be qualified on the negative list provided under section 3 and 4. What does it mean? It means that the work should not fall under section 3 and 4 first of all. If it falls under 3 and 4, not patentable outrightly. There is no need to see the further requirements of novelty, non-obviousness, utility. So only in cases where the subject matter qualifies on the test given under section 3 and 4, or say the subject matter is not falling under the purview of section 3 and 4, then it can be given a patent protection. Then it can be further tested and further gauged on various parameters, or say on subsequent parameters. They are called novelty, non-obviousness and utility. The third requirement, as discussed previously also by me superficially, is the requirement in the form of non-obviousness, that the invention over which the person is seeking the protection, that invention must ensure non-obviousness. We will discuss or have a very elaborate discussion on the point of non-obviousness. I mean, like, what does it mean? What is the concept of non-obviousness? How it has to be tested? How it has to be decided along with the case laws later on. The fourth and the final requirement to be fulfilled as far as the substantive requirements or the qualifications for obtaining the patents is concerned is the qualification in the form of utility. It means that the person seeking the patent must ensure utility, or the PTO, the Patent Trademark Office in Indian context, that is Controller General of Patents and Trademarks in India, has to first of all satisfy them itself that the invention over which the person is seeking the protection through an application has got some sort of industrial applicability, has got some sort of industrial capability, only then it can be granted a patent protection. So the friends, our focus or our primary concern would be with this second requirement today in our today's discourse, that is the requirement of novelty. And if you remember, all these requirements mentioned over here in this slide, these requirements are not explicitly given under any of the provisions of the Indian Patents Act in India. Rather, they are to be inferred, drawn out, carved out from the definitional clause read along with many other provisions of the Patents Act 1970. They are to be carved out. No explicit mention of these requirements in the form of qualifications to be fulfilled is given under the Patents Act India 1970. But if you see the Patent Act or legislations relating to giving protection to patents in other countries, say US, their regime provides a full-fledged protection. Moreover, their regime explicitly provides the qualifications, the requirements for obtaining the patent by purview of their legislation. Their legislation speaks out clearly that these are the various qualifications to be fulfilled by the person seeking the patent. But in our Indian context, Patents Act 1970 does not explicitly talk about the requirements. It imbibes those requirement in its language, in its sweep, in its steed, we will have to carve out, we will have to take out, we will have to infer those requirements one by one, and finally understand that these requirements are to be fulfilled to get the patent protection finally for the work or for the invention. Let us start discussing what does novelty mean. Let us start understanding the nuances relating to novelty. Let us start understanding some case laws relating to novelty in India. Friends, as far as the word novelty is concerned, I have previously mentioned it many times. I have informed my viewers earlier also that the requirement in the form of novelty, or say word in the form of novelty, the terminology novelty has not been used in our statute relating to patents, which is Patents Act 1970. It uses the word new invention. It does not use the word novelty as such. So is the case in UK. In UK as well, the word new is used, and for other qualifications, other substantive qualifications for obtaining the patent, the word, you see, inventive step in place of non-obviousness is used, and the word capable of industrial application is used in place of utility. If you see the next slide, in US, these qualifications are called novelty, non-obviousness and utility. If we jump to the previous slide, viewers, in India, these requirements are called new, inventive step, capable of industrial application. In US, they are called novelty, non-obviousness, utility. Friends, I would like to put across to all my viewers at this juncture that these requirements are same and similar. There lies only the terminological difference as far as these requirements are concerned. There does not lie any other requirement. When it comes to the test to determine or gauge the qualifications, it remains same in all the nations, I mean in US as well. When it comes to the concept relating to novelty, non-obviousness and utility, that same concept is applicable in India, but the terminology which is in use in India, that is new invention, that is inventive step and capable of industrial application. But by and large, Indian courts, they use them interchangeably. Moreover, that very comprehensive convention relating to intellectual properties, that is agreement on trade related aspects of intellectual property, that also talks interchangeably, or that also uses these terms interchangeably. So we are in kind of a freedom to use these words interchangeably. So we will be very often using these terms as what we call it, novelty, non-obviousness and utility, or maybe we will be using these terms as new, inventive step and capable of industrial application. So you will have to understand that they are one and the same thing. Well friends, I would like to start now the concept relating to novelty, but before that I would like to tell you some important points relating to the concept relating to novelty. See, they are separate requirements, this novelty, non-obviousness and utility, but they are related requirements for obtaining the patent protection. When I say they are related, it has got some sort of relevance here, or it has got some sort of relation in the form that these requirements, though are separate or to be proved separately, but they are related, as if you see in the case of novelty and non-obviousness, they are considered sometimes similar because the test relating to determine the novelty and non-obviousness is a very subtle test, is a very important test, is a very difficult test to be gauged by the person, to be applied by the person. So there lies a relation between these following requirements of obtaining the patent, though they are separate, are to be proved separately. The determination of these requirements proceeds on the assumption that the work in question is not prohibited by section 3 and 4. That everyone understand, and I presume that all my viewers are aware of this particular thing, that they will be only assessed, I mean the requirements, substantive requirements for obtaining the patent, the qualifications for obtaining the patent, they are to be assessed only in the case when we are satisfied on the ground that they are not prohibited by section 3 and 4. When we are assuming it that the works which are in question are not prohibited to be given patent protection under section 3 and 4. Novelty, our today's deliverable, our today's agenda, which as I have already discussed, is a substantive requirement, is a substantive qualification for obtaining the patent. Its meaning has to be understood by all the viewers and anybody interested in understanding the concept of novelty. Then the elements of novelty has to be conveyed or are to be understood by all the viewers in a very simplistic fashion. And some case laws, or say the test to determine, because the test has been propounded by the different courts in India and abroad to determine and to gauge the novelty involved in the invention. So let us see what does it mean. When it comes to meaning of novelty, friends, if somebody is willing to discern the meaning of novelty, or say the CGTDM, Controller General of Patent Trademark in India, if they have to discern the meaning of novelty, if they have to see whether the work applied for obtaining the patent is novel or not, they'll have to read two important provisions together of the Patents Act 1970. So section 21J and 21L are to be read together to understand the meaning of the word novelty. As I mentioned that the word novelty nowhere has been described and defined under the Patents Act 1970. We will have to understand it by reading of various provisions together, by taking the gist of various provisions together, by taking the interpretation of various provisions together. In this context, when it comes to meaning of novelty, section 21J and 21L, they are to be read together, and their combined reading will tell us, will convey the meaning of novelty for the purposes of the Patents Act 1970. Section 21J reads, invention means a new product or process involving an inventive step and capable of industrial application. We have previously on many occasions discussed this particular definition of the word invention given under the Patents Act 1970, which reads that invention means a new product or process involving an inventive step and capable of industrial application. Friends, I have earlier on many occasions highlighted the word new prefixed with the word product or process here. The word new is prefixed with the word product or process. This word new poses the requirement of novelty. It encompasses the requirement of novelty, but particularly this word new prefixed with the word product and process asks the person obtaining the patent on an invention to prove the newness involved in the work, to prove the novelty involved in the product or process, otherwise it cannot be given a patent protection. The next thing to be seen, the meaning of the word new invention defined under 21L. 21L reads, new invention means any invention or technology. Viewers, I would like to draw your attention here and specifically to those parts of this particular definition which are highlighted by me, which are demarcated by me in this definition. New invention means any invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing of patent application with complete specification. That is, the subject matter has not fallen in public domain or that it does not form part of the state of the art. Friends, this definition is very crucial, very pertinent to understand the meaning of the word novelty or meaning of the qualification in the form of novelty. And as you all know, without proving the work novel, patent cannot be granted. Here the new invention means any invention or technology which has not been anticipated by a publication. If you see, this definition in its purview postulates 3-4 elements to be fulfilled first of all by the person. I do not say that these are the positive postulates to be fulfilled. This definition of new invention provides some postulates, provides some requirements which will gonna negate the novelty. I mean, if somebody's work is anticipated by publication in any document, that would destroy the novelty involved in the work. If somebody's work is used in the country or elsewhere in the world before the date of the filing of the application with complete specification, that would destroy the novelty. If that has fallen in public domain, that would destroy the novelty, or it does not form part of the state of the art, it would destroy the novelty. So this definition does not provide positive list of the requirements to be seen, of the elements to be seen while proving the novelty. It provides a negative list of the things to be first of all avoided and discarded. Only then that particular invention would be called novel, or that particular invention will be termed as new invention. And as I mentioned that the combined reading of these two provisions shown on the slide, 2.1J and 2.1L, gives a fair idea to the person that it has to be new first of all. The product or a process which is the subject matter of the patent has to be new first of all, and new here means, as per 2.1L, new here in this context means something which has not been anticipated by publication in any document, which is not in use in the country India or elsewhere in the world. For example, when it comes to its use in country India or elsewhere in the world, what does it mean? Friends, it means it requires that it should not be in use in India first, and if it is used in another country, say in US, say in any European nation, still it would disqualify on the requirement of novelty, as it would get hit or negated by this particular element shown here under the section 2.1L, under the definition of section 2.1L. And further it reads that it should not have a subject matter which has fallen into the public domain or which has become a state of the art or a prior art. So first of all, friends, let us take out the important elements which we see mentioned under 2.1L to be taken out by all of us. What are those? These are the following important elements which we can easily take out from the definition given of the word new invention under 2.1L of the Patents Act 1970. These are the following elements to be seen, to be checked. If something which has been anticipated by publication in any document, it would not tantamount to be called a novel work, as it has already been anticipated. We will see what would constitute the publication, when the work would be called published, or say what is the meaning of the word anticipated by publication in any document here. Another element that can be inferred, that can be taken out from the definition provided under section 2.1L is as follows, that it should not be used in the country or elsewhere in the world. The another element or another ingredient, that the subject matter has not fallen into the public domain. If it has fallen into the public domain, it cannot be given a protection. And the last element which negates the novelty is as follows, that the subject matter does not form part of the state of the art. So these various elements or ingredients shown in this slide are the elements, if they are present or if their presence can be proved, then they will gonna destroy the novelty, they'll gonna disqualify the work or an invention to be given a patent protection. So primarily they are negatively worded elements which are going to negate the novelty involved, which are going to destroy the novelty involved in the work of the person. So we will have a very elaborate discussion on the meaning of these following, or say we'll have a very elaborate discussion as far as these following elements or ingredients negating novelty, destroying novelty are concerned, given under 21L read along with 21J of the Patents Act 1970. Few more things which I would like to highlight before jumping to their meaning. Friends, these are some of the very important concepts relating to patent, which I believe every student learning the patent law, studying the patent law or developing this subject must know and must understand. And moreover, when we would further jump to our discussion relating to the various elements of novelty which are going to destroy the novelty, we will require this knowledge as shown in this slide, which reads that the patent granted by the patent office does not necessarily to be a valid patent. I would like to elaborate this point. The very first point mentioned in this slide has to be elaborated. It reads that the patent granted by the patent office does not necessarily to be a valid patent. It means that even on an invalid patent granted by the patent office, a person can enjoy an exclusive right conferred on him. Moreover, it means in another way, or if you restate this definition in another manner, it means that it is not necessary that the patent office always grants a patent protection to a valid patent. They may grant a patent protection to an invalid patent. Another requirement is that the validity to be determined by the court when contested / objected. It means, viewers, that the validity of the patent which has already been granted and obtained, that is determined finally when the court receives any sort of a objection or opposition regarding that, and when there comes a contest relating to that, in that case that validity has to be assessed, in that case that validity has to be finally declared. So the patent would be declared valid not by the Patent Trademark Office, it would get declared valid by the court. This is what I want to convey to all my viewers. The conferment of the patent or a grant of the patent by the Patent Trademark Office or Patent Office is simply a conferment of the exclusive rights. It is not a declaration regarding the validity of the patent. The validity of the patent gets determined when it is contested or objected in the court of law, or sometimes some patents remains patented work as they are not contested, though they are invalid or they remain invalid. Invalid patent may remain operative unless declared invalid. As I told, a person can enjoy an exclusive right over a patent granted by the patent office if it has not been declared invalid by the court, and this objection has to be filed under section 64. Section 64 specifically clause E and F provides a ground to file the objection to the person interested in getting the patent declared invalid. By abiding to those grounds or by proving those grounds provided under section 64 E and F, the person can easily get the patent granted by the patent office declared invalid. So these are some of the points that you must remember, that the patent may be granted to a person irrespective of the novelty involved in it, irrespective of the non-obviousness involved on it, irrespective of the utility involved on it, or maybe some doubtful novelty, doubtful non-obviousness, doubtful utility involved in it, if they have erroneously granted a patent to it. I am not saying that they have a power to do this or do the same, but if they have done some kind of a mistake or a flaw while gauging or assessing or determining the requirements in the form of novelty, non-obviousness and utility, they can confer the patent right, which may get challenged in future by any person on the grounds provided under section 64. Exclusively section 64 E and F provides those grounds under which a person can challenge the validity, and if that comes into the favor of the challenger of the validity of the patent, then that particular patent would be declared invalid and it would go off the roll from the patent office, would fall into the public domain again. Well, friends, as we have taken out some elements relating to novelty, which are anticipation by publication, which are used in the country or elsewhere in the world and has not fallen into the public domain, the subject matter does not form part of the state of the art. These are the following elements of the novelty. Let us see what the Supreme Court of India says on novelty. We have a very celebrated case in India, or I will call a only case decided by the Supreme Court, which speaks so clearly and so elaborately on the point of the requirements for obtaining the patent. And this particular paragraph, which has been taken from this judgment, is talking about the requirement of novelty. It reads, "It is important to bear in mind that in order to be patentable, an improvement on something known before or a combination of different matters already known should be something more than a mere workshop improvement." Friends, this paragraph clearly says that on a workshop improvement, a patent cannot be granted, because workshop improvement of any kind of an invention will not be called a novel thing, because it already exists and some kind of an improvement has been made, a workshop improvement has been made, then that workshop improvement will not take that particular work to the merit of obtaining the patent. It further reads that the work must independently satisfy the test of invention or an inventive step. To be patentable, the improvement or the combination must produce a new result or a new article or a better or cheaper article. So this paragraph said in the case Vishwanath Prasad Radhesham versus Hindustan Metal Industries requires that to get the patent or to become patentable, there has to be improvement in the work, or say that improvement should not be the workshop improvement, that has to be the significant improvement. Further it says that the person must produce a new result or a new article or a better or cheaper article than before. The combination of old known integers may be so combined that thereby working interrelation they produce a new process or improved result. The mere collocation of more than one integers or things not involving the exercise of any inventive faculty does not qualify for the grant of patent. So we can easily understand that this particular paragraph, as said by Supreme Court in this judgment, which is Vishwanath Prasad Radhesham versus Hindustan Metal Industries in the year 1982, this paragraph requires the inventor to come up with a new manufacture, new produce, new product, new process, which must not be the combination of old known integers, which must not be a mere workshop improvement. That has to be something, if it is an improvement, that has to be something which is called significant improvement. Then it would be called novel. If we further go, as I have tried to take out certain important elements to be negated first of all when it comes to meaning of the novelty, or when it comes to the test of proving the novelty under section 2(1)(l), they are, the work must not be anticipated by publication. So let us see what does publication mean. Friends, publication here means published in any manner. It can be published in the print manner, by media manner, electronic manner. A thing may get published by word of mouth as well. So when it comes to publication of any work, because if it has been published, it would destroy the novelty and patent would not be granted, because the qualification will not get fulfilled. If it comes to proving the novelty, then the person seeking the patent has to prove that his work has not been anticipated anywhere by publication. As I said, that the publication here means publication in the form of print publication, in the form of electronic communication, in the form of media publication would constitute the publication. It would be called publication. One important thing that we must understand when it comes to meaning of the word publication, friends, if you see or have a look at this slide, which provides or which gives an idea about the meaning of the word publication and what constitutes publication with some example. This particular thing says or reads, see, publication simply means act of making known to the public. If you are making something known to the public, that would be called publication, for the purposes of negating this particular requirement, or for the purpose of understanding this requirement. Publication here means making something known to the public, be it in any manner, be it by print manner, be it by electronic manner, be it by your word of mouth, be it by keeping something into the public domain. That would tantamount to publication as far as the publication given under 2(1)L is concerned. So there must arise a question into the mind of the reader or say viewer, is posting on internet a publication? Yes, it is a publication. If you have posted something on internet and later you seek to get a patent protection on that work, you cannot get the work patented, as your work will stand disqualified on the requirement of novelty, as it has already been anticipated by publication in India. So print media, of course, anything which has been printed in media would also destroy the novelty of that thing. So no person who has already printed it into media can later ask for the patent protection and later claim novelty in that work, because it is no more novel, it has been anticipated by publication, it loses its novelty. Something in electronic media, something known to the public or made known to the public through electronic media would also destroy the novelty, cannot be termed as novel. Speech given by somebody, in the speech, suppose, viewers, let us exemplify, say a very renowned scientist involved into a very rigid kind of a research of his discipline or in his discipline, gives a speech somewhere about the working of his invention, say about the specifications of his invention. Can he get the patent when he applies it further, claiming that it is his novel work? That question or that kind of an analogy should come to the mind of the reader and viewer. Can he be given a patent in that case when he has already made it public, known to the public, and that through speech? Certainly the answer should be come into no, because it has already been anticipated by publication through a speech, it has already been made known to the public through speech. It cannot be granted a patent because it lacks the requisite novelty. It does not have that novelty which will rise it to the merit of getting the patent, but that is lacking, so no patent, because the scientist has committed a mistake by giving a speech regarding the working of his invention, regarding the specifications of his invention. So it has been already anticipated by publication. It would be termed as anticipated by publication. So is the case in lecture. A lecturer delivers a lecture in the classroom, and if he is a person involved or engaged in some kind of a innovation or inventive work, if he tells that thing to his audience through his lecture, then in that case, if he would require to seek the patent in future, he would be denied because it lacks the novelty. As it has been anticipated by publication, it has been made known to the public. So something which has been made known to the public cannot get the patent protection, cannot fetch the patent protection. There can be many things which we can bring under this head, under this element of novelty, which we call publication. There can be several ways of publication in today's technologically advanced world, where we come across various new means of communication coming to the fore every second day. Let us see one very important case law, that is a foreign case law, United States case law, giving an idea about what constitutes publication. In this case law, in Re Hall, Federal Circuit Court in 1986 says there are many ways in which a reference may be disseminated to the interested public. Public accessibility has been called the touchstone in determining whether a reference constitutes a printed publication. Friends, the most important part of this paragraph is where the court says public accessibility has been called the touchstone. It is the public accessibility which will be called the touchstone in determining whether the particular reference constitutes a publication. Something which has not been made accessible to the public. This question must arise into the mind of the person. Something, as we have seen the meaning of the word anticipation. Anticipation means making the public know about that work, or letting the public know about that work. Here in this case law, in Re Hall, Circuit Court says that the public accessibility is the touchstone in determining whether the reference constitutes publication. It means we will have to see whether the work was accessible, whether the published work or so-called published work which is in question, was that accessible to the public? If it was not accessible to the public, would that still be called a publication for the purposes of determining the novelty? Friends, this test is very important. It reads, there is no requirement of showing or proving that public accessed the work. Accessibility is one thing, or having an access is another. Something which has been made accessible by keeping into the public domain, maybe on a website, maybe in a library, maybe some audio cassette available in the market, maybe some voice recorded by a person available in the market, where he describes the invention, where he describes its specification. Those things which are available or have been made accessible, they will gonna destroy the novelty involved in that work, because they have been made accessible, as highlighted in Re Hall case by the Federal Circuit Court, that the touchstone to determine the novelty is the accessibility. It's not the access, it's the accessibility. Whether the person accessed it or not, that is immaterial, that would remain inconsequential, that would remain irrelevant. What remains relevant here is the accessibility, is the findability of that particular work. If it is findable, no matter it is buried somewhere, it is very difficult to find it. But if it is findable, if it is accessible, if it has been made accessible, then in that case, that particular work would be called fallen into the publication. That particular work would be called anticipated by publication, and it would lack novelty, it would destroy the novelty in that work. No patent can be granted to that kind of a work. Further, it says it should be findable, no matter buried somewhere. So accessibility and access are to be distinguished here. Accessibility means, in this particular context, it means, or it should be construed as findable. Having an access or proving or showing an access to the work is irrelevant. It means that one need not show that he had no access to the work. He has just to show that the work was findable, work was accessible. He is not supposed to prove that the work was accessible. Work was accessed by him on this and that date. He has to prove accessibility, findability of the work, no matter buried somewhere. Further, in Indian context, in Bishwanath Prasad Radheshyam versus Hindustan Metal Industries, the court held when document will be deemed to be published, and it reads, had the documents been placed in the hands of a competent craftsman endowed with the common general knowledge at the priority date, who was faced with the problem solved by the patentee, but without knowledge of the patented invention, would he have said, this gives me what I want? If some document is placed in the hands of a competent craftsman, and that particular craftsman is particularly facing or confronting a problem, solving something or some issue, if after having that document in his hands, he says that this gives me what I want, to put it in other form, we can say, if that document makes that particular thing obvious to a skilled worker for the practical purposes in the field concerned, in the state of the knowledge, then in that case it lacks the novelty, or that work, if later on claimed to be novel, it would lack the novelty, no patent can be granted to that thing. I would like to elaborate it in a very simplistic manner to my all viewers. Suppose a person skilled in the art, a craftsman in the art, is given a document describing the specifications of the invention. If he can solve his problems by referring to that particular document in which the specifications of the invention are given, if he can come out with the solutions, then in that case it does not have the novelty required for fetching the patent, and that work would be termed lacking the novelty, and it would destroy the element of novelty. No patent can be granted to that, as it has been anticipated by publication, which we understand making known to the public about the work in any manner. Say a document where the specifications of the invention are given, this document comprising those specifications, it means you have made the public known about the working of that invention on a previous occasion. If you will later file the patent on the same thing, you will be denied because your work lacks novelty, and that would hit by the ground mentioned under section 2L, which reads anticipation by publication. Further, we will have to see what does prior use mean. Section 2.1L provides us 4 elements to be negated. One, anticipation by publication, and the second is prior use. What does prior use mean? Friends, we will see its meaning, purposes, and some examples we will take to understand it. When it comes to prior use, in Egbert versus Lippmann in 1882, the court held that prior use means used in the country or elsewhere in the world. In India, the same terminology is used in the legislation under section 2.1L, something which is used in the country or elsewhere in the world. It means there has to be publicness involved, abandonment to the public of the work, or making it available to the public. Suppose, let me give you a very simple example to make you understand. One Mr. A is involved in one kind of a work which he may seek to obtain patent for in the future. If he reveals it to his friend and gives or hands it over to his friend to use that particular work, in that case that would tantamount to use, which we call a prior use of that work, and this prior use will destroy the novelty. But there lies a catch when it comes to this particular example given by me or forwarded by me. Suppose if you give something to your friend or your colleague to be used by him, not to be disclosed to the public, and he uses it stealthily, he uses it secretly without divulging, revealing or disclosing it to the public. In that case, it would remain a matter of argument or a question to be determined whether it lacked the novelty or not. You never know, the court may decide in your favor saying that it is novel because that prior use in this example is a use made by the friend of the inventor, and that use was restricted to him only, to the friend only, not to the public at large, and the public at large did not get to see that use. If the public at large get to see that work, in that case, obviously, of course, that would not be patentable because it loses the novelty. But if that work has been used by the friend in a very secretive manner, in a very clandestine fashion, in that case that may be given a patent. I said might be given a patent or may be given a patent, I am not sure about it. It may be a matter of contest or a debate to be decided by the court. When it further, what constitutes public domain? As the third element, when it talks about the novelty, it says that the subject matter should not fall into the public domain. It can fall into the public domain in many manners. So what does the work is deemed to have fallen into the public domain? With some examples we will understand it. Another requirement is the state of the art or prior art. Friends, the word state of the art is used in the Patents Act 1970 in India under section 2(1)(l). It does not use the word prior art, but in US the word prior art used. So interchangeably we can use these two terminologies. They are one and the same thing, they are synonymous. So what makes the subject matter state of the art? With some examples we will understand it. When it comes to state of the art, as I mentioned and highlighted that it is not defined under the Patents Act. In Vishwanath Prasad Radheshyam versus Hindustan Metal Industries, we get a fair idea as to what would constitute or what would be deemed as prior art. This section 2(1) of the Patent Act in various definitions, if combined with Vishwanath Prasad Radheshyam and Hindustan Metal Industries case or the holding of this case, we get a fair idea as to what would constitute the prior art. So prior art, by the combined reading of these previous two things, may be a publication, it may be a use anywhere in the world including India, it may be a prior knowledge in any form including word of mouth. Friends, kindly focus on these three things, that prior art may be by publication, prior art may be by a use anywhere in the world including India, or a prior art may be a prior knowledge in any form including word of mouth. So if your work has been published, has been used anywhere in the world including India, has become a prior knowledge in any form including India or any part of the country, in that case it would be called state of the art or prior art, and it cannot be given a patent protection. As all my viewers know and have understood from my previous lectures, that only a new invention can be given a patent, something which always available or something which lies in the public domain, something which exists, something which is known to the public, accessible to the public, something which is into the common domain, cannot be given a patent protection. An old invention cannot be given a patent protection. It has to be a new invention fulfilling the requirements of novelty, and novelty here means not anticipated by publication, not used in India or elsewhere in the world, not fall into the public domain, and does not constitute prior art as discussed by me. So these are the 3-4 things which are the takeaway for you at home from today's discourse. These are that the novelty must be first of all established by the person seeking the patent, and while establishing the novelty, which is one of the most important qualification for obtaining the patent, he has to prove that his work has not been anticipated by publication, must not be in use, his work must not lie into the public domain, and must not become a prior art or state of the art. That would tantamount to novelty, and from that he can easily fetch the patent protection. So friends, in the next time or in the next discourse, I'll deal with the next qualification, that is non-obviousness, which is a substantive qualification to be fulfilled, and in that discourse itself I will take you to that subtle difference between the novel and non-obviousness. So I rest here. Thank you. Have a good day.
With this note, thank you, sir. Thank you so very much. And dear friends, as Mr. Ashwani Sewal himself said, that we would be meeting again and would be discussing on more resourceful topics which he is going to deliver with the help of this EduSet platform. And if you have any feedback regarding this particular lecture, or if you want to ask any question from Mr. Sewal, then you can mail us at info.cec@nic.in. We would love to solve your queries the next time when Mr. Sewal visits our studio. Till then, take care. Goodbye. Thank you, sir. Thank you so very much.
Thank you very much.